it was wrongful conviction.
It was. It was. And speaking of that, that's a good segue. I did the interview with Justin Brooks today for the Justice Served TV True Crime Book Club for his book, which is called "You Might Go to Prison Even Though You're Innocent." It was great. It was fun. That's going to post for members tomorrow, probably midday ish, and then maybe a couple weeks down the road we'll flip it. So we'll do that every couple of weeks, I think. I'm thinking of getting Jodine Weber for the next one because she's got a great book, which is
Right.
kind of a fiction but has a lot of her life in it. An interesting book. Okay, so here we are. This is the order, and this is interestingly they did post this on the docket, so it's a little bit unusual that they put the order right there. So a little background: Kelsey Fitzsimmons indicted for one count of assault with a dangerous weapon. The dangerousness hearing was held on August 28, 2025 in the Essex Division of the Superior Court. We know who that was, right? Judge McCarthy. In an order dated that same day, the hearing judge found Fitzsimmons to be dangerous, but released her on conditions including, I always liked this when I think our law school newspaper or something was called Inter alia. Inter alia, among other things, that she abstain from alcohol and be subject to certain testing for alcohol use. The 58A order, and that's important, 58A, was temporarily stayed until September 8, 2025, when an order issued releasing Fitzsimmons subject to the imposed conditions. So then we go to September 10 of this year. Fitzsimmons moves for relief from the condition that she be subject to certain testing for alcohol use. After a hearing held the following day, the hearing judge, McCarthy, concluded that because Fitzsimmons could not comply with the alcohol testing as ordered, her release would endanger the safety of another person or the community. Now, remember, this is just a recitation by the appellate court of what they've read at the trial. This is
Right.
not an independent understanding of what happened. These are just the facts as they've been made available to them. And they're certainly going to dig much more deeply into this. Consequently, the hearing judge vacated the prior order of release and ordered Fitzsimmons held without bail. Fitzsimmons then filed a petition in the county court seeking relief from the order of commitment. She further asked the judge, a single justice, and we know who that was, right? Dewar.
You
Dewar.
previously known as
Du-
Justice Dewar
Dewar, but
is
now
Justice Dewar. It turns
Dewar.
out.
Yeah.
Your friend did correct you and correct our pronunciation.
Yep. I appreciate that as well. And I thought it was funny that he had the insight on the liquor. Anyway,
Well, except that we had somebody in our chat who's a co-owner of a liquor brand.
oh, really?
So yes, you're gonna get in touch. Gonna put you in touch.
Do they
Missy
need a
has
sponsorship?
all.
They want
Missy, we may need a sponsorship. Missy has all the deets.
Okay, good. Let's see. The single justice denied the petition and the Fitzsimmons appeals. The case is now before us under this particular rule, which applies to a petitioner appealing from a decision of a single justice, denying relief from an interlocutory ruling of the trial court. The rule requires a petitioner to set forth the reasons why review of the trial court decision cannot adequately be obtained on appeal from any final adverse judgment in the trial court or by any other available means. In other words, you got to exhaust all these other remedies.
Right.
Based on the record, we are persuaded that the appeal should proceed. Filing a petition pursuant to the code is the proper means for seeking relief from pretrial detention based on dangerousness in the Superior Court. Remember, the dangerousness is against Officer Noonan and the community. That's the analysis.
Because the dangerousness, because if she drinks, supposedly she will go out shooting, even though the facts of the case was that she was in her own house when her baby was ripped away from her. She's breastfeeding this child, not at the time, but she's breastfeeding the child. She goes upstairs, and then there's a dispute of facts as to whether or not she was trying to end her own life or whether she took aim at Officer Noonan. So my point is that the alcohol consumption has nothing to do with the facts of the case, and yet we're talking about her dangerousness in this order.
Yes, and there was some history. There was a bridal shower. There was some social event or two that in which alcohol was consumed. Crazy idea, but yeah, this judge has decided that was going to be a condition of her release. And now, if she can't do that test, then the safest place for everybody is for her to be in jail. The parties, so they reference the code in the cases Mendoza versus Commonwealth. As Fitzsimmons has no other means of obtaining adequate appellate relief of the pretrial detention order, this appeal may proceed with full briefing in the ordinary course. Now, that may just sound like, oh, okay, so that's not very normal. Normally, what happens is they take whatever was presented to the single justice and they review that as a panel. Nope, this time they're basically looking at this as a brand new process. And so there's going to be a briefing schedule. The party shall confer with the clerk to arrange an appropriate briefing schedule. Now,
which is a win for Tim Bradel, because he had said as one of the causes of action for his appeal, and I'm just saying causes of action, that's not the formal technical legal term, was that the judge below, Judge
McCarthy,
right? Judge McCarthy had done something wrong, had made the wrong decision, and then when it went up to Justice Dewar, she had used the wrong standard and didn't do a de novo review. So by having a briefing schedule, Michael, that's a whole de novo briefing schedule anew.
Yeah, and it is unusual. And what we're waiting for now, and I talked to Tim Bradel about it. I said, what do you think the schedule is to get the schedule? And he said today, and I've not seen anything on the docket, but it probably wouldn't be on the docket. Maybe they'd make a notation. Maybe that would just be handled in-house. But he said today or tomorrow at the latest. So what they're trying to do, obviously, the Fitzsimmons representatives are, motivated to get this in front of the court as soon as possible. We don't know what the prosecution's position is on this. Are they going to be limp-wristed like they were at the hearing where they did really nothing? Or are they going to be, more like they presented themselves in the brief to the single justice, which was much more in your face, much more we're right, they're wrong, much more we're doing the right thing by keeping her in jail. We don't know. But that's going to manifest itself in these briefing dates. Now, on October 27, Fitzsimmons files a motion to expedite in which she requested that the court grant oral argument and expedite a hearing. The request for oral argument is hereby denied without prejudice as premature. So what the court is saying is, we aren't even going to know whether you deserve really an oral argument until we see these briefs and we see where we're going. And the court, I'm getting the feeling because of this decision asking for a full hearing and further briefing that they are going to want oral argument. Just a thought. Maybe I'm dead wrong, but it seems to me they're going the extra mile to look at this as closely and as seriously as they can.
Well, yeah, and if they do that, then this is this is the Massachusetts Supreme Court, the Supreme Judicial Court. It's their their SCOTUS, so to speak, right? Then it's interesting because then they'll have a written decision, and they may be thinking far beyond in terms of what we think this case is about. They may be talking about maybe some type of substantive due process, because Tim did raise that in his appeal about constitutional issues. So he does have those preserved here.
Yeah, no, I think they've done all the right things to get the attention they need. In crafting an appropriate briefing schedule, the clerk shall give due consideration to the time sensitivity of this matter. So again, the clerk plays sort of referee in this, and both sides are going to submit dates. Clerk's going to work with them, and they're going to come up with something that everybody is happy with. We express no view on the merits of Fitzsimmons' claims at this preliminary juncture. So,
and I think I said that to you. I said when I was walking back to my office, I said the problem I have with all this right now, though, is that we're approaching Thanksgiving and Christmas, and she is still in jail when she went in and just sought modification of the manner and means of which she can comply with the Scram breathing test. And by the way, for all of you that forget, we still have Justice Serve TV has agreed to foot the bill for any alternative means of testing for her if that will help get her out.
Yep. And, it's really just a function of what's the alternative going to be, and let's get it going. I did a little bit of research on the panel, just we'll talk about it more at some later date. But I thought it was interesting. The Chief Justice is Kimberly Budd. Kimberly Budd, and I've got pictures and everything of these folks, but we'll get into that some other time because I want to get into this teacher shooting case. But one thing I found interesting about her, and this will be a flashback to some of the materials that were presented by Tim Bradle. Remember the ADA argument, and there's some suggestion that that was premature because they needed to exhaust an administrative remedy on that.
That's the Americans with Disabilities Act. Everyone,
yes.
People aren't familiar.
And I'm looking at her judicial, basically it's her resume. She worked on a number of ADA cases prior to her becoming the Chief Justice. I don't know. Does that mean anything? Is it going to matter? Is it going to impact what ultimately she decides or argues when her panel is discussing this? I don't know. Frank Graziano is another one of the members of the panel. And let's see, Scott Kafker is one of the panel members. Sergey Jorges Jr. is one of the panel members. And of course, who will not be on the panel?
Justice Dewar. Yeah.